Hello, my name is Andrew Griffin of the Law Offices of Andrew H. Griffin III, APC. I'm a bankruptcy attorney and I have been an attorney in the San Diego area for more than 37 years. And today I want to talk to you about whether your small business should file bankruptcy after suffering financial difficulty due to the coronavirus or the COVID-19. I'm getting many calls from small businesses who have questions as to whether they should now file bankruptcy. Many businesses were barely making a profit before the stay-at-home orders were issued. Now, small businesses which were considered non-essential have been ordered closed. Businesses ranging from restaurants to beauty salons are suffering because of the COVID-19 pandemic. Even if your business was not ordered closed, people are not spending their money the same way that they were before they were ordered to stay at home. I am now being asked, should my small business file bankruptcy due to the financial difficulty caused by COVID-19? My initial response is, don't file bankruptcy now. The entire nation is under economic stress. There are programs designed to help you get through the COVID-19 pandemic. Take advantage of these. One of these is government benefits. There are a number of United States government benefits, one of which is called PPP, or the Paycheck Protection Program. You should apply through your business bank or SBA broker. Now this loan can be forgiven if at least 75% of the proceeds are used to cover payroll costs and the rest on allowable expenses such as business rent, utilities, or mortgage interest over an 8-week period after the loan is made. It's a 2-year repayment plan with 1% interest. The payments are deferred for 6 months. The other program is the EIDL, or the Economic Injury Disaster Loan. Again, apply directly through the SBA. The loan is not forgivable, but the advance is. The advance can be up to $1,000 for each employee, and it's a 30-year repayment at 3.75% interest, but the payments are deferred for 1 year. Now, you can also file your taxes or defer your taxes. If you're expecting a refund, filing your taxes as soon as possible will get your refund to you sooner. On the other hand, you can defer until July 15, which could be helpful if you owe taxes. Now the IRS and the Franchise Tax Board have the same deadlines to file and the time to pay. Both are July 15, 2020. Those who need more time can file for a 6-month extension to file, but the deadline to pay remains July 15, 2020 as of April 15, 2020. Those who are on payment plans and cannot afford them can contact the IRS and Franchise Tax Board for relief options. Now, what you should need to know about your tax returns: most refunds arrive within 21 days. You can e-file for free. Refunds can be directly deposited into your bank account. The other way to do this is renegotiate bills. You can ask your credit card providers, utilities, medical providers, and other companies if they can help you make your payments more manageable. What you should know: credit card issuers may waive late fees, let you delay payments, or even lower your APR. Utilities and healthcare providers may extend deadlines and waive late fees. You could get lower cost internet, TV, or phone service if your introductory rate has expired. But what do you do if you have made the decision to shut down? Many small businesses have made the difficult decision to shut down and to terminate their businesses. The most common bankruptcy option for small business owners is called Chapter 7 bankruptcy. Chapter 7 bankruptcy can be used to help the principal of a small business when the debts of the business have grown too substantial to service. Under Chapter 7 bankruptcy, you have the opportunity to more easily control the business debts for which you would otherwise be personally liable. Business people involved in a sole proprietorship or a partnership generally find Chapter 7 is right for them. This is because liability for a business debt generally falls to the business owner in these kinds of enterprises. If you have decided that you're going to file or shut down, then there's no need to continue making any payments on any debt. Stop paying the debt and prepare for filing bankruptcy. And if you are a corporation or limited liability company, Chapter 7 bankruptcy is not usually as helpful as some of the other options available to you. When you file for Chapter 7 bankruptcy, you benefit from a stay that will halt most collection against your business debts. A trustee is then appointed with the duty of selling off the non-exempt assets of the business to pay off the debts. There are some positive consequences of Chapter 7. These positive consequences are: it provides a faster and easier liquidation of business assets. During a business bankruptcy, a trustee manages all of the complex logistics of selling off the assets of a business. Although you will almost inevitably lose all the assets, you don't have to worry about how they will be dispensed and whether your creditors receive their due. Chapter 7 bankruptcy also reduces credit score impact for non-sole proprietors. Under business entities that are considered legally separate from the principal, a business bankruptcy significantly reduces the possibility for credit score damage that you might face otherwise. Since you are not considered liable for such debt, your credit score can remain unscathed. Chapter 7 bankruptcy also clarifies taxes. How does bankruptcy affect taxes? Bankruptcy helps you to determine the full value of business assets and debts, so your tax burden will be accurate. This helps you avoid overpaying and may reduce your personal tax burden in the year that your business enters bankruptcy proceedings, saving you time and trouble later. Now, what do you do if you have made the decision to keep operating your business? Upon the filing of a Chapter 11 case, a debtor is permitted to continue the use or the operation of his business. The operation is however, subject to a number of restrictions. Everything is different about Chapter 11s than not just a big Chapter 13. There are three common types of bankruptcies. One is Chapter 7. Chapter 7 is a liquidation. It usually takes about 3 to 4 months, and there is no repayment of any of your debts. The filing fee is $335. Chapter 13 is a personal reorganization. There is a 3 to 5 year repayment plan, and the filing fee is $310. And Chapter 11 is a business or individual reorganization, and that term varies. The filing fee is $1,717. Now, if bankruptcy is necessary, you should use an attorney with significant bankruptcy experience. If you want an experienced bankruptcy firm, please call my team now at 619-440-5000 to schedule an appointment, or go to my website at www.andrewgriffinlawoffice.com. My name is Andrew Griffin III. I'm looking forward to helping you put the past behind you and enjoy a brighter and more hopeful future. Together, we can beat this and be more than conquerors.